Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion in estate planning. With over 3 decades of experience helping families protect their legacy, Tom has become a nationally recognized expert in estate, trust, and elder law, especially when it comes to complex planning needs. I'm Leann Lyon, and today's episode is one of the most critical and often misunderstood areas of estate law, special needs planning. Hello, Tom.
Hey, Leann. How are you this afternoon?
Great to see you. Thanks for being here. And Tom, let's just start with the basics. Why isn't traditional estate planning enough when somebody has a special needs family member?
Well, there's usually a few different deficiencies that you have to take into account. One is that an individual may rely upon needs-based government benefits as they get older, and if they receive an inheritance outright, that can disrupt those benefits. A second reason is that if it's a cognitive impairment as opposed to a physical impairment, there's a greater chance of exploitation if individuals receive inheritances directly in their name. Also, there's a presumption that people have that individuals that have special needs, especially if it's cognitive, that they can always be taken care of by their parents. But the law states that everyone is considered to be deemed emancipated at the age of 18. So sometimes you have to make sure that it's not only financial issues that are taken care of, but personal and medical issue needs are addressed as well.
So what is a special needs trust, and how does it help protect a loved one's eligibility for important benefits like Medicaid or SSI?
Okay, so basically there are 2 types of tracks of benefits, and that probably needs to be known from the outset. So, and also the issues with special needs trust is that it's not a one size fits all, because the category of peoples that wind up needing special needs generally fall as into the following. One is people that have been disabled since birth. That's typically the individual that has Down syndrome or cerebral palsy, and they get diagnosed pretty much at birth or shortly thereafter, or very severe autism, and they're never able to handle their personal and financial affairs. The other is an individual that has grown up and has worked a normal life for a period of time, and then unfortunately at some point in their 30s, 40s, 50s, they wind up getting a disability. Sometimes it's a physical disability, sometimes it's a traumatic brain injury, but there's different populations. And also the way we treat people when we set up a special needs trust is distinguish when someone has a physical need is able to make a lot of participation in their decisions for someone who is cognitively behind. But the main thing that a special needs trust addresses is what's called the SSI track. So once again, there are 2 types of tracks of benefits. The first is Social Security disability, and the other is the Supplemental Security income track. So in order to be eligible for either track of benefits, you have to first meet 2 criteria. So the one criteria, which is in common, is that you have a disability that is severe enough that you can't render or earn, a gainful living on your own. The difference is that under Social Security disability, that applies for an individual that has worked for 40 calendar quarters or 10 years. So let's say, for example, you and I have a couple of years on us. We're not teenagers anymore, but we're not old people. But let's say something happened and we were in an accident and we're no longer able to work. The fact that you and I each have been working for over 10 years would allow us to get Social Security disability, and that's a monthly benefit, just like Social Security, and it is tied in part to our work history as well as the fact that we're no longer able to work, period. And then after 2 years, you're typically eligible for Medicare as well. Now, the neat part about this is that special needs planning doesn't really have to tie into this. A lot of people think that you have any sort of disability that you have to have a special needs trust. But Bill Gates get, tongue in cheek, you'll say Bill Gates could get on SSD. I'm not sure if he would ever need it, but the idea it's not needs-based tested. So if someone left us an inheritance outright, we're still able to receive it. But a lot of people are on what's called the SSI track. And once again, you have to have a disability. But on top of that, you can't be making more than you can't have more than $2,000 in most states of what's called countable assets. And a countable asset is basically something that's generally deemed liquid. So, bank accounts, IRAs, stocks, bonds, mutual funds. So you really have to be broke. So it's a poverty program. But when you get supplemental security income, it's a very modest check. But the big thing that it provides for you is Medicaid. And that is tested by what you have. And let's say, for example, you have an inheritance and you have a child that has special needs. And let's say you have, $900,000, three kids, and you want to leave that child 300,000. If they get it outright, then they're going to lose their benefits. And if somebody has a lot of medical issues, that $300,000 can go really, really fast. So what a special needs trust does is clearly states that it is supposed to supplement rather than replace needs-based benefits. An independent party is appointed as the trustee. The person who is the beneficiary, it's for their use and their use only. Um, Although there can be what's called a supplemental use, like for example, for caregiving and housing. But really, the issue that you have with the special needs trust, is for the benefit of the beneficiary. They have no right to demand. The trust has to be irrevocable. It has to be non-assignable. But if it meets those criteria, what happens is the person still gets their SSI, they still get their Medicaid, and actually, in a number of cases now, we have people that are getting on HUD housing, which is a needs-based benefit. They get to keep all that. And many states have what's called waiver programs, so there are additional things that they can get from state to state. What happens is that the assets can be used for things that are above and beyond that. So let's say, for example, you have a child that has Down syndrome. They're 25 years old. They have a high functioning, and mom and dad want to do the proverbial trip to Disney World. They can use a portion of the trust to pay for the trip to Disney World. Or let's say, for example, someone has a physical incapacity and uh, they're going to be moving to some HUD housing, but we'd like to make sure that they maybe have a nice big screen TV or computer. It can be used for things like that. So it's really something to enhance somebody's quality of life.
So, one mistake that I've heard of happening is naming a disabled child directly into a will or a trust. What kind of consequences can that create?
Okay, so, well, I mean, if you name the child directly as a beneficiary and they are on the needs-based benefits, then they lose the needs-based benefits because they, once again, now have more than $2,000. Now, there are children that are named as beneficiaries in the wrong type of trust, which will disqualify their eligibility. So the main trust that you hear of is what's called a support trust. And that's where somebody goes to John Doe attorney at law who's, qualifications to, handle the trust matter. It doesn't exceed his desire to cash or check. And, he does a little bit of this, a little bit of that, and doesn't really know the law, but, he did a will once or twice before, so he's going to do that for the check that he gets from the client. And I say that very disparagingly, but unfortunately it happens a lot. And I don't think people are doing it for ill meaning, but they just don't think things through. And in this day and age, you ought to know better. But what generally they'll do is, mom and dad will come in and they'll say, look, we're concerned about our child. They're on needs-based benefits. And let's say they have severe autism or Asperger's, and it's to the point where they can't make medical or personal decisions or financial decisions. The idea is the attorney will say, well, let's set up a trust to make sure that they're taken care of. And it usually addresses one problem. And the problem that it does address by having a third party handle the money is that nobody's going to come along and, steal. The amount of abuse for the elderly and the special needs population is just rampant in this country. So it's at least you're going to get that done. However, the language that they use in a support trust is that the assets and the income are available for health, education, maintenance, and support, or they call it the HEMS standard. And once the government, when they audit a trust, or whether it's in a will or a separate document, they're going to disqualify the person from needs-based benefits. So it's important to make sure that you have the special needs trust, the right type of trust. And it's also important to make sure you have the right language because there's a number of different types of special needs trust. The main one, if you're doing planning for a parent or someone who's going to be giving money to the disabled individual for their benefit, you want to have what's called a third party trust. There's other sorts of trust that you can use what's called first party trust. And I've seen people sometimes use the wrong language in the special needs trust, and one's more restrictive than the other. So you need to make sure that the person not only knows how to do a special needs trust, but gives you the right one.
Wow, that's a lot to know. Good we have experts like you to guide people through it. So let's talk about choosing a trustee. What should families consider when appointing somebody to manage a special needs trust?
This is probably, if not the most important question, at least one of the two or three most important questions you can ask with a special needs trust. Many people have a tendency to want to appoint family, and I get that. More often than not, when I'm dealing with any other form of trust, whether it's a revocable living trust, or a bloodline trust, marital trust, we appoint individuals. We think that if there's qualified family, that should work. And I get that. The problem with a special needs trust is that there are rules that you must follow. And if you don't follow those rules correctly, then your beneficiary can uh, lose their needs-based benefits, or the other thing that can happen is there's going to be a requirement to pay back for the trust for the benefits that were lost. It's really could be a mess. So I've told people I've been doing this for 36 years. And one thing I have never done in 36 years, despite knowing this area of law pretty well, is serve as a special needs trustee. I've always thought that this is the big exception that you need to have a corporate trustee. Now, not just any corporate trustee. There's lots of banks and trust companies that are good in managing money, but they have no idea what to do as far as handling needs-based benefits. There are certain trust companies and banks that will specialize in the handling of special needs trusts, and you need to reach out for one of those. The concern that many people have is that if the bank or the trust company is not client service oriented, which sometimes happens when they merge and people retire, get replaced by other individuals, and also the concern about the cost. Well, as to the cost, a lot of times many of these institutions will charge something comparable to what they would charge for money management anyway. And also, I tell people if you mess up the trust, it's going to cost you more than what the money manager's doing at the corporate trustee level. But there is a way that you can deal with the issue of client service, and I get that because I've had cases where somebody appointed, ABC Bank to be the trustee, and for years they were a wonderful trustee, but there was a merger, and then the new management was not very friendly, and the people couldn't get in touch with, the people at the corporate level and the trust level to get decisions made, or they're just being treated unfairly. And there has been occasion where I've heard that the response when the person complained to say, "Look, we'd like to have you resign or be removed," is, "What are you going to do about it?" So what you can do about it when you view a good check and balances, appoint what's called a trust protector. And the trust protector is where you get the family member who you would otherwise use as an executor or trustee for many other purposes, somebody who's good with money and trustworthy, and they have the ability to do two things. One is that they can oversee what the corporate trustee is doing. And the second thing that they can do, which is extremely important, and the most important thing they do, is they can hire and fire a corporate trustee without cause. That's important because if you try to go to court to remove a corporate trustee, you have to show with clear, convincing evidence that they breached their fiduciary duty. And that's a very high standard in law to reach. So it's nice to be able to do something without any reason whatsoever. So if ABC Bank is not taking care of the beneficiary, the trust protector, whether it's somebody's brother or aunt or uncle who's named in that position, it's nice to know that they can get rid of the corporate trustee and replace them with somebody else. I found that oftentimes, at the very least, what it has done is it has kept the financial institutions honest, for lack of a better term. If they know there's a chance that they could get fired, they tend to be a little more flexible. But you really want somebody that's qualified to handle it, and the corporate trustee is the ones that I most assuredly recommend.
So, if a family hasn't done any planning yet and something happens to the parent, what options are still available? Is it ever too late?
Well, it's not too late. So, and there's two things that will generally happen. Now, let's say, for example, if somebody had a will and they left the money outright to their child, or they set up one of those support trusts. In New Jersey, we can do what's called reformation. And what that means is we would go into court and say that, here's the will, and it left a third to our, beneficiary John, who has um, a variety of, physical impairments, which renders him to be incapacitated, and also needing a SSI. And we'll say that, unfortunately, if the parents knew that the trust would disqualify them for benefits, that they would have done a special needs trust instead. It's based on a law called the doctrine of probable intent. The idea being that if they gotten proper counsel, they would have done the proper trust. And the courts have been very, very interesting in the state of New Jersey about allowing reformation to occur. Now, let's assume they didn't do any planning whatsoever, which unfortunately does happen, Leann. And that's where, they're like half the country. We're going to get around to it tomorrow. But what's that old saying? Yesterday's gone, tomorrow never comes. And they pass away. At that point, you can't do what's called a third party trust. You can do what's called a first party trust. And what you would do is petition the court when you're administering the estate and to basically allow for a special needs trust to be established. And it works the same way as a third party trust. So let me explain the difference. If a trust has been set up for me by mom and dad and the will's there, then if it needs to be changed, it's mom and dad's money. It's a third party. It's not, let's say let's say I have a horrible accident. I'm physically incapacitated and I rely on Medicaid. Well, if mom and dad are leaving me money in a trust that doesn't work, it's still their money. It's third party. Now, let's say on the other hand, once they pass away and there's no will under the laws of intestate administration, that share of the estate that's supposed to go to me is considered mine the day they breathe their last. So it's not considered third party money anymore, even though it came from a third party. So for cases like that, and the other one, which is when somebody gets a settlement for a personal injury action, I can have a trust set up for me. However, because it's considered my money, the state, through the federal laws, is allowed to put more restrictions on the administration of the trust. For example, you have to get approval for that the trust set up. You have to notify the state Medicaid office whenever assets come into the trust, not just at the beginning, but if there are subsequent assets that come in. You have to do reports every year. And here's the big thing. When you pass away, the beneficiary, whatever's left in the trust first has to go to repay the state for whatever benefits that it expended on behalf of individuals during their lifetime. So let's say I'm the beneficiary and, the government spends, $500,000 on my care, and there's $300,000 left in the trust when I die. Well, all $300,000 is going to go to the state. However, if my parents have done a proper special needs trust, when I pass away, that $300,000 is going to go to the family. And the reason why that's allowed is that even though you may have an incapacity, and someone might argue there's a moral reason that when mom and dad should take care of you legally, children don't have a right to an inheritance. So as such, there's no requirement for that state payback. Even also, there's no annual requirement for an accounting, although I can't stress enough that you always want to keep the books available because you can get audited at any time.
Well, that is it for today's episode. Thank you for joining us on The Estate Blueprint. If you have a loved one with special needs, remember, good planning isn't just about legal documents. It's about peace of mind. To learn more or connect with Tom Begley's team, visit begley3law.com. And if this episode helped you, remember to subscribe, share, or leave a review. Thank you, Tom.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.